Hi, this is Kip from Malik and Malik. And today I'm going to be talking about what I'm going to call consistency. And I'm going to so I had a recent jury trial that we won with the claimant. And um, in consistency, ultimately talking with the jurors, a couple of the jurors that I could find uh, walking out of the courthouse after the thing was finished. I asked them what was the why they decide why they choose for our client, and their position was that this client had consistently documented her injury and her injury at the specific body part. And so consistency, and it was this right knee injury, um, and so consistency kind of, it's interesting how it played out in this particular workers comp jury trial, because um, what ended up happening is this person, when they first got injured, somewhere it was miscommunicated to an on-site nurse that this individual had hit her knee on a door, and there was surveillance video footage of the actual injury event, and you could see in the surveillance footage that this claimant did not hit her knee on the door. In fact, she essentially twisted her knee, or placed her knee in a weird position, and then that's what caused the knee injury. But somehow, initially with this nurse, it was misheard or miscommunicated, and she had documented that this injured worker hit her knee on the door. And again, the video evidence clearly showed that she didn't hit her knee on the door. The injured worker had sworn up and down that she did not tell this nurse or that she hit her knee on the door. But it was not just that one document. It was it was a hospital record, and maybe one or two other records where this hit the knee on the door mechanism injury was documented. Um, and so, in a sense, it was consistent, and that this misstatement of how this person was injured was consistently, and that was kind of not great. Although it was also documented in ER records, and there was a statement that the injured worker claims was her actual statement, and it matched what she said, how she said she got injured. So, and so the trial was really about, whether or not she hit her knee on the door, and if she clearly didn't hit her knee on the door, and so did she actually injure her knee? Again, we had video evidence, but the thing that was really beneficial, and why I say consistency, is this injured worker, and why the jury ultimately, one of the reasons why they chose for our injured worker, and granting the condition that was requested, was that the injured worker had consistently indicated that, notwithstanding the specific precise way that the knee was injured, that she had injured her knee. So she indicated that she injured that knee at the nurse station. Right after she went to the nurse station, she went to the ER, and then she went subsequently to the ER. She went to occupational health and physical therapy for that right knee. And so the jury was like, this person consistently indicated that she had injured that right knee. And if she didn't injure her right knee either at work or at all, then it was kind of insane. She's going to these medical appointments and treatments, because, I don't know, it's fun or something like that. So that injured worker, that consistency was beneficial in ultimately getting her condition added to the claim. Obviously, she had to go through an entire jury trial, which isn't the most fun endeavor for the injured worker, but it did work out for her. So beyond that, being consistent with how you really want to, when you get injured, you want to be unless it's like a 2-day oh, I injured my back and 2 days later I'm perfectly back to normal and there's no issues. You really don't want to wait, and you want to go seek medical treatment and get it documented right away. You want to seek medical treatment right away, whether that's ER or urgent care or your primary care physician, or you find a BWC doctor, a physician of record, some type of medical provider to document, one, how you got injured, and then two, document physical exam findings. If you hurt your back, for instance, your back, you want them to document your range of motion. Is your range of motion reduced? How much is it reduced by? Are there physical exam findings? Did they take an X-ray and these sorts of things? So you want to get it documented as close to the time that the injury occurred as possible. I've had folks come in, and I had somebody come in where they're like, yeah, I injured my knee, and I didn't tell anybody about it, but I did tell this guy over here, but I didn't actually officially report it. And then I didn't seek any medical treatment because they had me doing something easier, and it really didn't bother me. So 3 months later, I waited, and then I went ahead and I went to the doctor, and I was like, man, I hurt my knee way back, months prior. You got to make a decision. You really have to. Once you get injured, you cannot hang out and sit on it. Now, obviously, if that's you and I'm talking to you and you're that person, by all means, pursue the claim. I mean, if it legitimately happened at work, pursue your workers' comp claim, get a workers' comp attorney involved. I mean, honestly, I would say about 80-90% of our claims are, it's always some weird twist or some angle or something that, makes it, a sure thing. There's a trick where it's not a sure thing. And in that instance, waiting 3 months, it's not great. But in that instance, honestly, you really do want a workers' comp attorney involved versus going it alone, because in that case, it's just that time difference is going to cause it's going to impact the difficulty level of your claim. And so you want somebody who knows what they're doing, playing around with it. But yeah, you want to get treatment as soon as possible. If you have some kind of process at your job to report injuries, you want to do that. Whether it's filing an accident report or at the very least, emailing somebody, texting somebody, having some kind of documentation that you communicated it to your employer or somebody and they were aware of it. Now, there's no requirement necessarily in Ohio. In some states, they're kind of draconian. Like, I don't know if it's like South Carolina or North Carolina, and I don't do South Carolina or North Carolina law, but I looked into it because somebody had gotten injured there, and the issue was whether the jurisdiction was, whether it was an Ohio claim or a North Carolina claim. And I was like, you need to contact the attorney from that state. But I looked at it and I was like, whoa, this is kind of frightening, because you have to, in whatever state this was, it was like you had to give notice to your employer within like 14 days. And if you didn't, then you're kind of SOL. So it's not required in Ohio. The requirement in Ohio is you have to file your claim within a year of the date of injury. But nevertheless, you want to let people know so that they can't say, oh, you never told us, we weren't aware, and maybe it happened at home or maybe it happened here. So you want to go report it, get medical treatment, and then you just want to be consistent with the mechanism of injury. They're going to be looking, and it's kind of I honestly think it's more frustrating than that, because when you go to the urgent care, in particular in ERs, these urgent care folks, the doctors and the nurses and whatnot, I mean, they're focused on triaging people, taking care of people. They're not necessarily focused on, is it documented precisely as, as the injured worker states. And sometimes people aren't always the best historians as to how they got injured. If that's you, write it down or record it. Write it down and record it, and then bring it. This is how I got injured. But it's going to help you versus being super vague when you go to the ER. Oh, got injured at work. Well, how? I mean, if it's not written there, Or if it's just like, I was working and I noticed my back hurt. I mean, the employer is going to be like, hey, there's no real mechanism of injury here, and it's question about whether something that you did at work actually causes versus you just, you're getting old or whatever. So you want to be consistent and you want to be precise on how you describe your mechanism of injury. And then if you're consistent and precise, and you want to be consistent with every provider you go to, you want to describe your injury the exact same way. And then also you want to, if your neck hurts and your lower back hurts and your right knee hurts, you want to tell urgent care, my neck hurts, my lower back hurts, and my right knee hurts. And you need to make sure that all those things are addressed and examined and looked at. That doesn't always happen, particularly when it's like a more traumatic injury, because typically when it's a more traumatic thing, the focus is on the most pressing thing, whatever the providers are focusing on. You'll see that a lot with claims is, it might be that the shoulder is the most pressing thing. So the focus is on the shoulder and the treatment and the claim will be on the shoulder. But then it's like, oh, actually my neck hurts and it's hurt from day, one. You still want to, if you can, you want to document that your neck hurts as well. You want to make that point to your BWC doctor. Hey, doctor, I get that you're focusing on my shoulder. My neck hurts as well. And then and what's critical in that aspect is if in Ohio, there has to be some evidence, like you have an allowed claim and in year 2 of your claim, you want to pursue like, a neck injury. There has to be some evidence in the first year of that you injured your neck, because if you're trying to say it was directly caused by the work injury and there's no evidence, there's no medical evidence, then you're precluded from pursuing that condition on that basis. Now, if you're saying the neck was caused on a flow-through basis, that's a different issue. But yeah, you really want to be consistent. And in this case, it worked out for this injured worker. She won. The jury believed her, and then they found that the evidence was credible to support that injured worker's claim. But where things get tricky is again where there's inconsistencies and vagueness. So you always want to be consistent and precise if you can about everything. So so that's me talking about the importance of consistency. And the other big thing with any of these workers' comp claims is workers' comp in the state of Ohio, as I always say in these videos, is incredibly complicated, and there's multiple twists and turns and little twists and turns of how the law applies, and arguments that may be brought up, and evidence that you might need to present, etc. 100% get a workers' comp attorney involved. You can either reach out to us, see if we are going to get involved, or if you want to hire us, Malik and Malik. Otherwise, ask your coworkers, your family, friends, for ask them, hey, who do you know who's a good workers' comp attorney? Who helped Joe with his workers' comp claim? Oh, that was so and so. Oh, what's their information, or how do I find them? And call them. If you need to, or look on Google, look up work injury, workers' comp claim, workers' comp injury attorney, etc. And then read the reviews, and then call an attorney or call a number of attorneys. You want to get somebody who you're going to be comfortable with, because, these workers' comp claims could go on for quite a while. So you want somebody you can trust, somebody who's going to communicate with you, and, it's going to benefit you to work with somebody that you have a harmonious relationship with. So anyways, this is Kip from Malik and Malik. Hopefully you found something helpful from watching this video. I thank you for watching it.